This podcast is sponsored by Murgitroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgitroyd.com/podcasts.
Hello and welcome to the 5th season of Murgitroyd's Innovation Talks podcasts. We're delighted you have joined us. If you have any questions, you can email us at innovation.talks@murgitroyd.com or contact us via Twitter @Murgitroyd. And please remember to subscribe so you don't miss any future episodes. So let's go straight into today's podcast.
Hello there, my name's Catherine Bonner. I'm Southampton office lead here at Murgitroyd and Director Patents. I'm really excited today to be joined by Peter Wilson, Director Patents from our York office.
Hello, Catherine. It's nice to be here.
Hello, Peter. Yes, we're going to talk today about how to successfully grow your IP portfolio. Peter and I are both patent attorneys, so the focus of our discussion on this podcast will be on patents, although obviously there are trademarks and designs that can form part of an IP portfolio. So we'll start off, I think, by discussing our experience. So, Peter, you've probably got a lot of experience of working with clients and thinking of building up an IP portfolio. Is that true?
Yes, I think that is something that I feel I do have. A couple of examples in particular that might spring to mind where I've been right in at the start with a bit of technology that has originated in a university that has ultimately then been spun out into a company initially owned by the university, taken forwards, building the portfolio through various stages as that company grows. In the two cases I have in mind, all the way through to a float on the stock exchange, and the issues that arise as you grow effectively from that single good idea in an academic environment out into a commercial environment and into an environment where you are a not insignificant enterprise with perhaps a range of products and technologies. It is a fascinating process to be involved in.
University spin-outs are an interesting one to start with there. I have too, Peter, been involved in a number of IP portfolios at that stage. And I think you'll agree there are very different needs at the very early stage in perhaps a small portfolio, one patent application perhaps, through to having a portfolio at a different stage in that company life cycle.
Yes, I think that's very true. And very often different priorities and different mindsets as well. And managing the growth process and the learning process in that way is an important part of portfolio management. Universities are perhaps a lot more commercially minded than they were 20 or 30 years ago. But ultimately, a research university is still primarily about research. There will be an imperative for publication and that kind of thing, which, as we know with patents, does not always sit readily with the requirement to keep matters secret until you've got your patent protection in place. So that mindset in itself needs to be managed to some extent. It's still a valuable thing in an early growing company, but it needs to be managed to some extent.
Yes, in an early stages, I think there's a real tension between trying to create a buzz about your new idea and get as much information out there through various channels, be it LinkedIn or through publication in a scientific journal, a tension between that publication and disclosure and the absolutely key message that we all always try and tell our clients, that it's absolutely key to keep your invention under wraps and not disclose it, keep it secret ahead of filing a patent application. I think once that first application has gone on file and the SME, if I've worked with them, or the university or the spin-out company, once they've seen that process, I think the next round of innovation, there's greater buy-in to that approach. But yes, I think there's a tension there. Peter, you've also worked beyond the spin-out stage, as you were saying, the next stage.
Well, that's true. And that in itself is an interesting process, because certainly in several of the examples that I could think of, there was perhaps one particular, in a sense, quite narrow innovation, quite narrow discovery perhaps of academic interest that came out of that university research group that was admittedly then identified perhaps as a candidate for something that could be commercializable. But you do then tend to see the process through several generations as perhaps One example that springs to mind was in the field of manufacturing of a material which had a number of applications. So you then progress on perhaps to a second generation, which might be devices based on that material, perhaps to a third generation, which might be systems and signal processing. And that process in itself is quite interesting as well, guiding and reacting to the developments within the company as it moves through the stages of its own growth and making sure that they're protected.
And I think advising during that process, it's really key for the SME, the spin-out company or the larger company to find the right IP advisor, someone who's going to understand that process and grow with them. And equally, the IP advisor needs to understand that there are different tensions each of those stages. I'd love, being a patent attorney, to file for protection for absolutely everything, but really sometimes there's a tension between the cost and the relative benefit of spending that on protection for a company. And so there needs to be a more targeted approach, often I find, in building an IP portfolio. So understanding the business is key, and understanding the commercial aspects and where they might lead to, right through potentially to buyout or flotation, indeed.
Yes, indeed. And I think that is where the value of an advisor that has both the technical expertise appropriate to your particular area of industry and the commercial acumen to sit and work with you on that is important. And of course, the possibility of bringing in colleagues who have the niche expertise that you need is very valuable. But I think it's quite important, particularly in this sort of situation, to have a lead advisor with a strong handle on the business and on the objectives of the business. And certainly you talk about a couple of the ones that I've been involved with that went through an initial public offer where perhaps the IP was absolutely critical to that. I think in one instance made up something like a third of the offer document. And you realise that this is what they are selling. This is a key asset value for the company. And it is a process to be gone through to secure and monetize that asset value. And that really is what patents are about for these businesses.
Yes, and really good to see that in the offer document, to see the final outcome, the conclusion of it. We're sometimes involved along the way, but great, as you have had, Peter, to see that really through from the beginning right through to the end. I think IP portfolio management needs to be active, particularly in this building phase. You really want to have a handle on the costs and that they're going to provide a benefit. There's a risk with spending, I think, a lot of money on an area that perhaps doesn't turn out to be commercially useful or act as a useful block to competitors. We'd all like a crystal ball. I'm not sure we can say at the outset which are the key patents, but active management, active discussion with your IP advisor throughout the building, the portfolio process should hopefully match some of that and mitigate risk or provide the patent application proprietor with an idea of where the risks are. I think being aware of them is just as important as just trying to mitigate.
Yes, I think that's very true. I think it isn't a process that should be undertaken lightly. There are costs involved and there are active management of the costs and the risks associated with those costs is important. But for businesses, particularly, I think, at this growing stage, but with something valuable to protect, it is nevertheless very important that there are huge risks associated with not doing so, of course, as well. So active management of that is very important to make sure that the patents and applications that we are building in the portfolio are still looking like they're going to do what the applicant wants them to do.
Yes, and we've talked primarily about patents and patent applications, as I indicated we would do at the outset, but I have one particular example I'm thinking of where a company that I've worked with predominantly in the telecommunications space was also looking to build their portfolio, and we added in some other types of intellectual property rights. So we started to look at design registrations, applications we could look to protect the overall look, feel and character of some of their products and areas of their products, trade secrets, trademarks, trade dress, and some utility models can also be added into the IP portfolio. Not all of those rights are registrable. Trade secrets must be kept under wraps and are not a registrable right. But when you're looking at an entire kit, if you like, of a portfolio, there can be a number of different elements and they're all valuable. All of that technical know-how, the nuts and bolts of how the apparatus or the manufacturing process works. Too often, I think an IP advisor or a patent attorney, I love a patent application. We can be too focused on patents. And it's really important for SMEs, owner-managed businesses, and those going through this portfolio building process to look up and look beyond and see IP rights as a whole.
Yes, indeed. I can think of examples. I can think of both good and less good examples amongst companies that I've worked with. But I would in particular think that the area of trade secrets can be a neglected one in that regard. They are difficult to protect. Secrecy isn't always the easiest thing to do, particularly when you're a relatively small fish in a big pond. But nevertheless, it is an option. It is a way of protecting things either that can't be patented or a way of protecting that valuable know-how that is part of the corpus of what you have within the company, maybe sitting under the umbrella of some good patents. And certainly one of the things I think an advisor can be doing is assisting in the process of recordal, safeguarding, and other such things associated with maintenance of key trade secrets within a business.
Yes, there's a really important aspect there. We touched on it earlier, but that maintenance and active management of the entire IP portfolio. It's no good recording a trade secret somewhere and nobody knowing about it and nobody updating it. The metadata, the information associated with that trade secret, we would have the inventor really in the patent application world of things, or perhaps the CTO or the IP manager, but somebody needs to be responsible for the information in the IP portfolio, including the trade secret portfolio, and be maintaining that and updating it and using it and pruning it where necessary well. These intellectual property rights we've talked about as we're talking about building a portfolio and perhaps moving through stages of finance for a company or ahead of a flotation, these are important assets. And there can be value, as you've already indicated, Peter, associated with those assets. And that's the same, whether they're patent applications or trade secrets. We need really to get across, I feel often, to the companies we work with, that all of their intellectual property has value. It's not the same as the kit standing on the forecourt or the stuff in the warehouse, but it really is there and should be listed and managed accordingly.
Absolutely. I think that is crucially important. And there is an increasing realization of that, I think, particularly for high-tech SMEs, that this is a core business asset. It has value in every respect of the word. Indeed, in that respect, it isn't that dissimilar to tangible assets. Of course, it isn't a tangible asset, but I think there is that growing realization that proper value must be ascribed to it and it must be treated accordingly. And as you say, actively managed and looked after in order to make sure that it retains and ideally grows that value.
Yes, Peter, and having an IP advisor alongside you through that process can not only, I believe, simplify the process, but lead to really good quality management of that and good quality use of the IP assets. It's been really fascinating talking to you about this, Peter, and I'm sure we can talk for ages about portfolios we've built up and where we've seen them go. It's been a really, really nice chat. So thank you for your time today, Peter.
Thank you, Catherine.
Thanks for your time today. We hope you found today's podcast valuable. And remember to subscribe so you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgitroyd.com.